Wake up, buyer payer
I don't know if we're
people.
live on it.
It's a beautiful day. Go grab yourself another cup of Joe and say hello to Jim and
We
Michelle
have the weird
Rhoads
audio
on the
setup.
Buy
If you're there,
Here,
good
Pay Here
morning.
Morning Show.
So
Take it away,
somebody
you
jump in
two.
and say hello.
Good morning. This is an interesting thing that we're experiencing. If you guys are there and can hear us, go ahead and say hello and
Please
let us know that you can hear us. It's kind of quiet on our side, so just don't know if something strange in the setup. Every day's an adventure,
isn't it? Though
it really
that's
is.
part of the fun. Mystery of going live, right?
It really is. It really is. So let us know if you can hear us. So we're it's Monday.
Mm-hmm.
Indeed. And we've got a little bit of not very many announcements.
No, just a couple.
Today.
Marietta. I keep saying Marietta. I don't see an R in there anymore. Like it's Mid-Atlantic Independent Auto Dealers Association.
Miata?
But,
sorry, that's a car.
But that conference starts on Sunday, so that'll run September 24th through 26th in Atlantic City. So those of you in that corner of the country ought to get involved in that. And then you've got LHPH Capital Conference coming up in October. That'll be the 12th through the 14th, and Michelle and I will be broadcasting live from out there on Friday the 13th.
Yeah.
So
that's kind of spooky. So if you guys can hear us, please let us know so that we know that we weren't able to hear all of the morning stuff.
Yeah.
So if
everything looks okay on our end, but it just didn't sound right.
Good morning, George. I'm assuming that you can hear us. So
George must be getting
Marietta coming up, and then we've got the LHPH conference on the 12th, 13th, and 14th. Like you said, Friday the 13th.
Mm-hmm.
We'll be broadcasting. We're going to make it lucky.
Yeah.
So it'll be good.
I love to joke about I'm not superstitious, but I am a little stitious, right?
You're marginally stitious.
Yeah, right. And also we decided on this coming Friday we're going to do Friday Night Lights episode. We're going to talk about a connection between football and Buy Here, Pay Here.
I think Jim's seen that show before, and we kind of decided that I'd never seen it, and so we've been watching that. And Jim, that's the kind of football that Jim kind of did, and as it's Friday night was a big thing, high school ball, and in his small town, and it was a big deal.
It was a big deal in my small town, but I didn't realize how big a deal it was until I moved to Texas somewhere around 2004.
Yeah.
And Texas, it's every bit as big a deal in Texas football, and of course college ball on Saturdays. But we're just going to talk about how what kind of parallels there are between the Buy Here, Pay Here business and just business in general.
Because you all know that that's probably a thread in every conversation that we ever have is Buy Here, Pay Here. So it's like, oh, this is applicable. So you'll get to learn on Friday how Friday Night Lights is applicable to Buy Here, Pay Here. And it may be, we may do other ones. There was an awful lot that we've listened to and seen. Also, good morning, Facebook user. I posted on there. You could hear us. So
they're getting us. So the internet is working.
It's working.
Good.
So today's topic
is breach of contract, or who breached the contract. Is it us as the dealer, or is it the Buy Here, Pay Here customer?
Mm-hmm. And we've had a little bit of conversation about that.
And this comes up.
And we see it.
It's one of those kind of secondary topics that doesn't come up very often, but it's, there's been some stuff on social media lately that kind of spurred the conversation for me. And occasionally we have a conversation with clients, in this context, but let's just make sure everybody understands right off the top. We're not attorneys. We're not offering legal advice here.
Every once in a while we do a melodrama and we pretend we are, but we usually preface it with, this is a melodrama and we're pretending to be attorneys.
Sure.
Oh, hi Facebook user who's Karen from Charlotte.
Good morning, Karen.
Good morning.
Yeah, so this topic is something that I think we see a lot of threads on social media around different things that are kind of, you're getting into gray areas that really, when we get ourselves as dealers into gray areas, we run a risk of making a mistake. So we need to keep things black and white as well as we can. And this is an area when we talk about a contract, as I said to Michelle, when there's a dispute, or there's a problem and we want to sue the customer, or we want to repossess the customer, if we call our attorney and say, hey, what can I do about this? I promise you, the first thing the attorney's typically going to ask is,
what's in the contract?
What's the contract say? Send me a copy of the contract.
But let me ask you this: I don't know this. Before you move forward with something that it might be punitive in any way, do you contact an attorney and ask them if it's a good idea? Because it's a good idea. We're just saying it's a good idea, because there's no plausible deniability, and it's just like you can't say, well, I didn't know. It's like, it's contracts. So contact an attorney. But
and I think for this, it's like, look, we get it. The chances of a customer actually filing suit against you is low. But those of us that are on Steve Levine's email list with Ignite, we know that it happens. I mean, he sends stuff, actual cases of things that have happened in different pockets of the country, and they're not all huge dealers.
And it might not be. I mean, how easy? What's the? It's harder for someone to go to an attorney than it is for them to go to the Better Business Bureau, to go to the state, to go to whatever regulatory, that they'll file a complaint.
Yeah, and some of what we're talking about here is pure business. Like it's legal. It's like the contract and the language in the contract and how we enforce the contract. Some of what we're talking about here is very much legal. Some of it would be more ethical. But for today, I'd really prefer to stay in the context of legal. And I don't want to forget to mention, I looked it up and I couldn't find the way to copy the link, as I often do, was a post that I did back in February of 2021, where I asked dealers, when you contract a buy here, pay your customer, do you view the car or the collateral as your car or the customer's car? Okay, so let's cover that ground first, because it's kind of that old thing about possession is 9/10 of the law, right? Like we've all heard that. But in this case, what we're really asking is, it's more mentally. Like the contract says the same, and all of those 10 customers, 7 out of 10 dealers said, I view it as their car.
Not my car.
You can bet when the customer has some worn out tires or brake pads, the dealer's probably going to treat it like, that's your responsibility. That's your car. It's your job to maintain it. And in that poll, again, more than 2 years ago, dealers said, 7 out of 10 said they view it as the customer's car.
Can I'm asking, I mean, to me, in a way, it kind of looks like wanting your cake and wanting to eat it too. And so is it their car or is it your car? Because if it's their car, I mean, is it something that that ethically that we can say, I'm sorry, I don't like how I don't like how you're using your car, and so I want to enact punitive whatever. So
we haven't explained yet. Tyler Simmons put in a suggestion there, which I agree. Counselor Library with Hudson Cook is excellent. Steve Levine's email list at Ignite is definitely, just go to Ignite Consulting Partners and subscribe to their email list. He's got a lot of great stuff. And we know you're not likely to end up in front of an attorney on this. It's not likely. But if it's the one case, and like if we could set practices in place where we, we're able to avoid this. What we haven't explained yet, Michelle, is that the main thing that came up is we see kind of this thing about dealers getting frustrated about customers using their cars for Uber and Lyft.
George just said this comes up regarding Uber drivers.
Yeah, for sure.
Which
That's
is
one of the ones.
It's and just so consumer also. It's like Uber is a great way for someone to make side money to be able to support their family better. And so, and I know it's in a car, but it's like like honest work. They're out there hustling to find ways to feed their family and pay their car payment and all that kind of stuff. And it's a very low bar in being able to get into it. So not a lot of interviewing, but it's like you can start immediately and work as much as you want. So there are a lot of reasons why I think people that are our customers would look at that as I need to supplement our income. We just had this thing here, and my son just, did this, and I now have medical bills or whatever. And so how can we supplement? And so I think that's something
And that's true. If you're talking about supplemental for a month or two, that's one thing. But what we're seeing, like I saw one this morning on social where the dealer was saying that they got a car back and it had an ungodly amount of miles in like 10 or 12 months, like, 150,000, something ridiculous. Like, and so obviously the problem there is that it degrades the collateral. But the question in my mind, and I can't help when I think about this, like when I had my dealership, it was in the state of Oklahoma. Well, Oklahoma is a garnishment state. We could do small claims action. You could file a suit against the customer.
And you did.
And we did some. And had plenty of success with it. But in that case, you could go to the courthouse, and for roughly $200, you could file an action and enforce your contract. And then when you were awarded a judgment, you could garnish the customer's wages. So the reason it's important to me is, and I'm hopeful that one day we would have that across the country, because in some states where you don't have that, it just happens too often that the customer walks away from a contract with no consequence. And why is that important? Because George brought up the Uber thing. Well, let me say, George, that you're the dealer and I'm financing the car from you. Well, if I'm paying you for the car, it's my car. I just have a finance arrangement with you. I'm making payments to you, and I'm going to ultimately own this car. And if I want to run the wheels off of it, and suddenly, I've degraded it to the point where it's just a pile of metal, it's worth $500. I still owe you the full contract amount, regardless of what's happened with the car and the collateral. So I still have to follow. That's my problem. I have to follow through on the payments to you. Now, we know this is knowledge gap stuff, right? This is where the customer doesn't understand that. But also, even if the customer understands it, in some cases, there's no recourse. If I run the collateral all the way to the ground, my credit's already a problem. And now George repossesses the car from me, and I still owe him $13,000 on the account, picking numbers and being ridiculous. But it's like, if I still owe George, I still am obligated to make the payments. So there's a difference between the car and the collateral and the contract. And so we have a job to do in the buy here, pay here space. But I'm just saying, and I hear this also in service departments. You'll hear stories from dealers about my service advisor said that, we need transmission in this car, but the miles when they bought it was this, and the miles today are this. They're putting a lot of miles on it, boss. What do you want to do? Well, what is how many miles? Like, if I buy the car, it's mine. Like, if I want to go see my cousin in Nebraska,
every other week. Yeah.
This also comes up with GPS radius stuff. And so again, we're not attorneys over here. We're simply saying, if you just look at the language in the contracts, it's like, what does your contract say? So it's like, if we can't enforce the contract, but the problem becomes when we start enforcing things that aren't exactly in the contract, just because you're upset, like the thing with Uber and Lyft, it's a big question. People, it's a thing. Like,
we are seeing dealers put specific things in their contract that says this vehicle will not be used for, like taxiing and these. I can't think of what the words are, but we've seen that they are putting that in the contract.
Sure.
But there's a lot of contracts out there that don't have anything that specifically speak to this.
Ride sharing might be the
ride sharing.
Terminology you're looking for, but regardless, is like there's other things. Like, this is one example of where the collateral gets used differently. Many years ago, I heard an attorney named Bill Maypother, may he rest in peace, he passed some years ago, but I remember him talking about something called an insecurity clause. So let's talk about what an insecurity clause looks like. And again, not attorneys over here. I remember as a dealer looking for language to create an insecurity clause in my contract, or choosing one that had one. And in the simplest form, what that is going to be, if I'm a dealer and I'm financing the inventory, the collateral here, and if I have reason to believe that my collateral is being diminished or destroyed or taken away, then I would have the opportunity to act. Now that's tricky. That's a little gray area. Like, how specific is the information? If you got information that this customer's mad at you, Mr. Dealer, and they're going to take this car out and run it off a bridge into the lake on Friday, well, it's hearsay. It's something verbal that you heard, but it's like, can I act to protect my collateral? Well, sure, in a contract, we should be able to act to protect our collateral, but based on what information? Like, how specific is it? The other one that comes up, I just want to make sure and get it said so I don't forget. One of the ones that we see happen that also is kind of this gray area where I think dealers can really get themselves in trouble is when they allow a customer to pay late, like they have a history of letting the customer pay late. And let's say, for example, just pick some numbers. Let's say that at one point in the contract, you allowed the customer to pay 20 days late and you didn't act to repossess, for whatever reason. And now the customer's been back on track for some time, but now they fall behind again. And now they're 14 days late. But because you've got some other information or because you're upset with them based on some information, now you're going to repossess at 14 days late. Well, that's a problem. And that's not speaking as an attorney. That's just saying you created precedent. Your contract said this, you allowed the customer to do this, and now you change your mind, you're going to do it differently. And so this is the thing about, and there's a form called a notice of strict compliance, which, and again, not an attorney over here, but we've used this stuff by seeking it from attorneys in the past, is that when you're going to change practices on a customer, and some of this stuff like we're talking about, like it needs to be in the contract at the time. And if you're going to start enforcing the contract differently, then you have to notify
that's a question that comes up frequently with dealers that we've worked with. It's like, so this is happening and we've done this in the past and it's becoming a problem. And so one of the first things that as I've listened, Jim's like, well, you need to send them notice. And then you need to be consistent to that notice.
Right.
Which kind of, you roll the whole thing back. It's like, let's be consistent with the contract period. And then you don't ever have that problem. If they're late, they're late. But we're talking about Uber drivers and all of that. But if you're going to enforce something in the contract that you haven't enforced before, you're going to have to give them proper notice. And that's not just, hey, I sent him a text or whatever. There are forms, it's a very formalized thing. And then you have to be consistent, because if you send that to them and then they make their payments on time for 3 months and then they're 14 days late and you're not dropping the hammer, then it's like, well, that's null and void.
Right. Yeah, so I think, and George says here, when you take it out of the buy here, pay here business, it becomes more clear. Why? Well, because in buy here, pay here, we have a unique situation where we're financing our own goods. And there are some distinctions about that. Like when you're financing your own goods, it's not like you're a lender providing a simple loan to buy something else. That would make you a simple lender. In this case, we're not quite that. We're using a retail installment contract. Think about the phrasing: retail installment contract. So it's not a loan agreement. It's a contract. I'm retailing merchandise. I'm allowing you to pay for it in installments. So we have a different kind of layer of things in our contract and our arrangement. And I'm just saying, let's involve attorneys. Michelle and I aren't attorneys. We just want to keep dealers out of trouble. And we want to create clear communication. Like in a white hat context, we talk a lot about, growing up in Oklahoma, that thing about good fences make good neighbors. Like that was a thing. Like we talked about that. That was a real thing. People understood boundaries and you honored those boundaries.
And sometimes you had to go out and enforce them. And word would get out, hey, they enforce these boundaries. Don't go. I hear stories about Jim's dad is out there, people joyriding on the land, and he's out there and stops them and says, you stop now. And then he had to prosecute a couple and then it just stopped.
But it's not about, it's about just having clear understanding and making sure that people, do what is understood. And so in this case, that's all we're really suggesting is let's be clear and let's don't act based on something that we haven't specified in the contract, because that's where I'm saying when we talk about something like breach of contract, I'm saying this is where dealers, I feel like, get in trouble potentially, is by stepping out of bounds and enforcing a contract based on something that's not specifically in the language of the contract.
We were talking this morning about the topic, and I noticed that Jim wrote down on the list of things, because we have like a little sheet that we fill out.
I'm forgetful.
Is that buy here, pay here, kind of like in the same realm as lease here, pay here, and that because I was thinking about, well, when you lease a car instead of when you buy a car, that they do put mileage restrictions. And it's like part of the contract
Absolutely.
that if you drive it more than this, that at the end of the lease, if you want to purchase or whatever, that you're going to have to pay this.
Mhm.
And it's a clear understanding that, and I think that normally it's like 12,000 or something miles a year or whatever. And that if you think you're going to drive more, you just let them know, and then they adjust that. And it's like your payment may go up some, but this will work. But that there's a real clear, and leasing there's a real clear thing about how many miles you can drive.
Sure.
And that is, if you're dealing with a lot of Uber drivers, that is, as just a general like business type person, it's like that would be more attractive if you know that you had a lot of people that were doing that. I wanted to mention, like, we have friends that do leasing, and it's like it's a different model. It's but Nick Markosian, who's now on the NIADA board, I noticed that he has a lease here, pay here, but he also started a gig rentals. And so I think that we'll have to have him on the show or something to talk about it, but it's like he decided this is a problem even in leasing. And so we're going to separate those. And so people have an option here where they know this is a gig rental. If you need it for the week, then you can rent it for the week. And it's low cost, whatever. It ends up being more than what a regular payment would be every month. But it's so, you find ways to be able to allow them to be able to make a living, and that you can feel comfortable and you can feel safe, and that there's very clear fences. There's lots of ways of doing that.
Yeah. We also hear, I think I barely touched on it, we also hear dealers trying to enforce like a radius thing based on GPS geofencing. And I'm just saying, let's be super careful about that. Like, as a non-attorney, I hear that and I think you're going to tell me I can't go visit my cousin in Nebraska. It's like with a car that I'm making payments on, I'm just financing it from you, but it's mine.
And okay, so again,
go ahead.
It's like I've been in dealerships where they're policing their inventory, and they're like, they got people in GPS every day. And it's like, because the energy they put towards the customer is very punitive. And it's like, GPS can be something when that becomes a practice to watch where your cars are, that becomes a different kind of culture that you're creating in your dealership. Right. And so, it's like, well, we're watching and they're doing this. It's like, okay, I get it that you want to watch and protect your asset, but is it their asset or your asset? And if it's your asset, then, clear fences kind of thing.
Is it? Yeah. So let's be clear about that.
Yeah. I just, for me, I mean, I understand protecting your assets. There just seems to be something like there is such a level of distrust when it's your team, your team at the dealership it perpetuates distrust of your customer.
Sure. So again, I think we would like to see dealers be super clear, and of course, dealers need to build and enforce the contract. That's not what we're suggesting at all. We know you need to build and enforce the contract. So perhaps an addendum, perhaps get some legal advice and see if an addendum can go in your contract. That maybe ask them about an insecurity clause. Maybe ask about excess mileage. I mean, you mentioned the lease thing, and that's yet another example. Another benefit of leasing is having ability to
a different understanding.
It's still, if in that scenario, if the customer reached the end of the lease term and they hit their residual and they've overused the car by X number of miles, there's still a collectability question. I mean, will the customer have the money to pay for the miles that they've overused? And so again, for me, it's really just, I hope the day will come that across the country, and I just think we need to figure out how to get that at every state level so that a contract is enforceable. Like, and let me just run through it quickly. We got a few minutes. Let me just make sure people would hear what we used to be able to say. Sometimes it didn't have to be in the contract, but in the interest of trying to communicate to the customer on the front end, I often in our contracts, we had language and we would present it verbally to also cover this thing about insurance is the clearest way to educate the customer and to say, it's your responsibility to maintain your insurance. If you don't keep your full coverage insurance and an accident should happen, in Oklahoma, we had tornadoes. It could be whatever. It could be somebody steal the car from you. It's important for you to understand, Mr. and Mrs. Customer, that if that car is stolen from you, for example, that you still have an obligation on this contract. So the car is the collateral. And yes, we all hope the collateral holds up well and lasts a long time and has good value. But if something should happen to that collateral, if the car was stolen and you had no insurance, you still have this obligation on the contract.
That's an interesting thing to educate people on.
Yeah.
I mean, it's like, this is not that we're lending you the individual money and this is what we're using as collateral.
Yeah.
And so it's like that agreement, regardless of whether or not the collateral is here, is between you and I.
Well, and the other thing that does, and the reason it's significant, and I think it kind of relates to this conversation we're talking about here, is, again, going back to Oklahoma with it, and garnishment is allowed in other states where dealers could take the same posture. But I remember making this claim in the past on social media, and people pushed back. I said, that's ridiculous. We could never do that. Well, in Oklahoma, if the customer were hiding the car, we knew they were blocking, they were chaining the car to a tree, or they were hiding it in their or they were hiding in the garage, and we knew it. We could see that they were clearly hiding in the garage. Well, I would just simply, because in the state of Oklahoma, I have a car and I have a contract. Fine, hide the car. I still have your signature on this contract, and I know where you're employed. So go hide the car and set it on fire. It's like I still have the contract over here. So I think as dealers, sometimes we get a little too wrapped up in the possession of the car as collateral. It's just collateral. You still have this contract over here, regardless of the car.
But some states don't have the same ability.
But we had the ability in that.
Yeah.
But I think you could still, even in those cases, depending on the language in your contract, you might not be able to garnish wages, but you can still get that judgment. And so there should be remedies in most every state.
In most every state, you can get a judgment on a contract if they're not.
Yeah, but like people say, it's like judgment's it's a piece of paper that's worthless. Some would take that position, right? And so I think it's really a question of enforceability. And every state will be a little different about that in terms of what you can enforce. But getting the judgment shouldn't be a big deal. You march down to the courthouse and spend a few $100s to filing fee, and the customer probably doesn't show up in court, and now you've got your judgment against them for the full amount of the contract. So now it's net of the repo proceeds if you have a repo, but I'm simply saying in those cases where there was no collateral, customer wrecked the car, it went to the junkyard, it's a couple $100s, and there was no insurance. Well, I still have a contract, customer still owes me that. That's unfortunate that the collateral went away, but the customer still owes the contract. And of course I would be agreeable. We would typically, and I tell one other quick thing for folks to know about why it was so helpful. We would be able to negotiate through customers who, let me just kind of run through it. Out of 10 people that we might file action against, maybe 2 or 3 showed up. Okay. And when they did, the judge would send us down the hall to mediation. We'd meet with a mediator and reach an understanding. And I can just tell you that in my experience, I was plenty agreeable as a creditor. I would be very workable about the payments. Look, I just want you to follow through on the understanding that, you still have this understanding, and I want you to follow through, and it could be a small payment. But if the judge set the payment amount, like if it just went to they wanted to dispute and wanted to fight, and the judge ultimately set the payment often was 2 or 3 times higher than the original car payment was set on the contract. So it's like, as a dealer creditor, I was able to say, you don't want the judge to set the payment. Like, we've got customers paying 3 times what their original payment was. You don't want the judge to do that. Let's reach an understanding. And then if they failed on that, then you'd have to go back to the court and, get some remedy. But you get the idea is we have to separate the car from the contract. And we have to be careful as dealers to just go out there and get real personal about the collateral and get upset about them overusing the miles, and taking action based on that, because I hear dealers kind of pushing back on warranty claims and this and that based on, whatever the language in the warranty thing is, that's a different agreement than whatever we're talking about over here. But this on the regional.
That was actually something that we were talking about, like the reinsurance. It could be, this covers this if you, as long as you're keeping it under this amount of miles or whatever. And,
of course, we expect the customer to honor their understanding. We expect them to fulfill whatever the contract says. I think it's reasonable to expect that the consumer and their lawyer are going to expect us as a dealer to honor what we said we would do in the contract. Sometimes that's a warranty, sometimes whatever, like we're going to have to honor. And that just goes back to the language. So, if you're in an uncomfortable area there, check the language on your contract. And if you need to get an attorney to help you write an addendum and make your contract a little stronger, more specific, I think it's fine to enforce whatever the language says. But, if you enter into that agreement and it's compliant with your state or whatever, then it should be enforceable. But we just see dealers really kind of living they're treading in dangerous waters in some of this stuff. It's pretty gray, and they're taking some action.
That's where I was like, a customer might, get a little out of sorts, because you're like, no, I'm not going to do the thing because you did the thing, and all of the stuff. And they may not go to an attorney, but darn it all, if you get enough complaints, you do not want to be an example. Because we're watching what's happening with regulatory commissions and making people an example, and you do not want to be the one that's the example. And so how do you stay out of having complaints and clear fences and making sure your contract is because, like Jim said, if it goes to court, it's going to be, what did your contract say?
And the late Bill Maypother also said, we should all as dealers do everything we can to keep our customers out of attorneys' offices. So it's just, let's not put ourselves in that position. Let's find other remedies and work things out and not end up there. So that's probably a good place to wrap up for today. I think, like I said, this is a big subject. And just remember, we're just speaking to you as your non-attorney friends over here. We're just friends trying to help keep you out of trouble.
So it's like, have clear understandings, clear understandings, and make sure that you are consistent with those understandings and that you're ready to enforce the understandings.
Sure.
And for whatever it is that your state allows you to do to enforce those understandings, be prepared to do that.
And don't ever let it get personal. Don't let it get personal. It's a business matter.
Yep.
And so if they mistreat the car, they mistreat the car. It's a legal and business matter.
Well, we're in the buyer payer business. We're going to have customers that mistreat the car.
It's not personal.
It's not personal. So
anyway.
All right. Well,
let's
happy
wrap up,
Monday. I hope everybody has a great day today. And
George Spat, Tyler Simmons, Karen Barnett, thanks for tuning in.
Thank you so much.
Your feedback.
We appreciate your feedback during the show, and hope you guys have a great week. Happy Monday again, and we will see you on Wednesday with White Hat Wednesday.
See you then.
Thanks so much, everybody. Talk to you later.